So next up we have Virginia Griffin Donnell and Brian Ludmer. She founded the family law firm Griffin Donnell and Associates APC based in Los Angeles, California. In addition to being a lawyer, Virginia is an experienced licensed school psychologist, specializing in litigating complex custody disputes, including those involving parental alienation. Virginia understands the subtleties and full picture of an alienation case in order to best advocate for the best interest of the relationship between a child and targeted parent. Brian Ludmer is a skilled attorney in business and family law. His practice focuses on high conflict divorce, parental alienation, and high net worth property and income disputes. Having fostered a successful resolution to parental alienation for his own family, Brian is actively sought out as a leader and a lead or strategic counsel by clients on matters where this devastating and poorly understood form of child abuse hurts children and parents alike. Working with organizations such as Parental Alienation Awareness Organization and International Support Network for Alienated Families, Brian has been the keynote speaker at numerous events around the world. Welcome, Virginia and Brian.
So I'll just split it directly in half. Is that okay? Okay. Good afternoon. I'll use this if you don't mind. Sure. Good afternoon. Is it on? Good afternoon. Test, test. Can you hear me? Yes. Okay, my name's Virginia, as it was announced, and I'm an attorney in Los Angeles. I also have a practice in San Francisco. I handle cases that rejected parents come to me with regarding the severe resist-refuse cases, parental alienation cases, parent-child contact problem cases. So the name has changed and continues to change, but we're dealing with the phenomenon of parental alienation, and specifically this talk is about the information and misinformation surrounding the term reunification camps. And I'm going to briefly delve into the federal legislation. In addition, I'm going to talk about state bills that have come down. And in a quick presentation, this is designed to be a 20 to 30 minute presentation. I'll take about 10 minutes. And then talk a little bit about what the term reunification really means. So starting with a little bit about me, I am a licensed school psychologist. I have been for 20 years. That's different from regular psychology because school psychologists assess data, and we essentially are the federal fund gatekeepers for children who are at risk academically and behaviorally. So when a client comes to my office, the first thing I do is I use data, a potential client. I use data and I look at what specific data points are being demonstrated to me to see if they're actually a rejected parent and that this is truly a resist-refuse case. So my practice, I can't say the word specializes yet, and that's a term of art. A certified family law specialist is a specific type of practice, but I do only practice family law, and my niche is parental alienation cases. Okay, also I want to say an important disclaimer as an attorney. This presentation represents my viewpoints. It doesn't necessarily represent the viewpoints of any organization, including PASG, et cetera. These slides will be presented can be accessible through my website, and I can give them to each of you if you're interested. Okay, we're going to talk a little bit about parent-child contact problems, the brief history of the term reunification, the law, and legislation. So a brief history. How many of you, show of hands, know that California was the first state to enact no-fault divorce? Okay. And no-fault divorce is now becoming more prevalent throughout the world, including in England, I believe, it's passing. It was instituted in California in 1969. And the goal and intention for no-fault divorce was to stop with the litigious finger-pointing and blaming between parties that were going through a divorce. It's called the Family Law Act. The attempt was to reduce acrimony in domestic relations cases, and by eliminating fault and introducing social services staff in family courts, by reducing the adversarial nature of the proceedings, the hope was that the finger-pointing and the blame would stop. How many of you think that family law has finger-pointing and blaming still? Raise your hands. Back then, there was a fear that parties would channel the blame and acrimony of divorce into the child custody issues to influence the outcome of the financial issues. Therefore, in 1969, the law said parties could not put the reasons that an award of custody to the other parent was not in the child's best interests in their pleadings. How many of you are aware that there are pleadings right now that talk about the fitness of a parent and the best interest of a child? Raise your hand if you know what therapeutic jurisprudence is. I'm going to read this slide so that it doesn't cause anxiety since I'm going so fast. Therapeutic jurisprudence is the study of the role of law as a therapeutic agent. It is an interdisciplinary endeavor designed to produce scholarship that can be particularly effective for law reform. Isn't that exciting? This table's bothering me, it's in the way. Isn't it exciting that it's an interdisciplinary endeavor? How many of you think that that's exciting? Raise your hand. Very good. So who can explain, Demos, what is interdisciplinary? What does that term mean?
Law, social work, psychology, counselors, school counselors, pastoral care.
How many psychologists are in here? Raise your hand. Very good. Judges, attorneys, guardians ad litem, social workers. What am I missing? Counselors. Very good. So isn't it exciting that we have therapeutic jurisprudence? Before today, okay, scratch that. Okay, let's talk about the term reunification and the origin of that term. I'm specifically narrowly focused to California at this point, okay? When a child is abused and they go to school and they have a bruise, what happens? They get reported to in fact, teachers, psychologists, counselors are all mandated reporters. So that goes to the Department of Child and Family Services or the Child Protective Services, whatever it's called, right? Those cases fall under the purview of dependency court. How many of you know that there's a difference between dependency court and family court? Very good. So in dependency court, the focus is on helping children reunify with fit parents. The dependency courts want to reunify families. Therefore, reunification services was originally created to reunify families. Family court has a rule in California Code 3026 that says reunification services shall not be ordered. Why is that? Family courts assume that if there's a parent, one fit parent, that the parents have it covered. And the family courts are not as invested as dependency courts in reunifying families. So what did the attorneys and the legislators do to get around it? They created a legislative code called California Family Code 3190 and 3191. So the issue is, in legislation today, the term reunification is a bad word, right? I'm going to get there. Okay, the legislators created the term counseling and allowed for a family code in California that said California bench officers may order counseling if there's a problem in the family. And they didn't use the term therapy because that could be considered a medical term. There could be religious or other objections to the term therapy. So it was a constitutional issue. But specifically, California Family Code 3190 said the court may require parties or other parties involved in it, may require parents or any other party involved to go to counseling. But they narrowed the focus of 3190 to the following three main issues. One, communication between the parties. See the red in the middle? So think about it. If you've got parties that don't communicate well together, in California, you can ask the court to order therapy or counseling. We don't use the word therapy because of what I said before. Also, Family Code 3190 can be used to reduce conflict regarding custody. How many of you know that there's conflict regarding custody? right? Or improve the quality of parenting skills. So I recently put orders into place for a father client of mine in Santa Clara. I better not speak that way. I better be careful what I say hypothetically because this is being broadcast.
Somewhere.
Right. So communication between the parties, reduction of conflict, and the ability to help parenting skills. Why is this important? Because the resist-refuse cases generally occur with children ages 8 and older. And that's where you start to see, in general, I'm speaking very generally now, parent-child contact problems. So we have the issue of reunification camps. What is it about these camps? As you probably know, in the media, there is a proliferation of misinformation saying that there are concentration camps with barbed wire. How many of you are aware of this? Raise your hand. Okay. Where'd this term come from? Well, Dr. Matt Sullivan gave me the permission to show this slide in the cover of his book, Overcoming Barriers. Originally, Sullivan, Deutsch, and Peggy Ward created a camp for families that's now not in operation due to COVID and other reasons, but that's where the term came from. Other intensive therapy programs, yes.
Could I just intervene here for 1 sec? And the interesting part about that is overcoming barriers did not require protective separation. It involved the whole family, and yet that's where the pejorative term is being taken from.
Very good. In addition, thank you, Brian. In addition, there are other intensive therapy programs, including Building Family Bridges. By the way, with Family Bridges, if you Google Building Family Bridges, you see it. I struggled with that when I watched Yvonne present earlier this year. One Family at a Time, that's Dr. Lynn Steinberg. Transitioning Family, Rebecca Bailey. Northern California, Turning Points for Families, Linda Gottlieb, who's speaking right now in the other room on Zoom. And again, I cannot and do not endorse or promote any program just because I'm a lawyer, so I'm going to say that, right? Okay, family code sections distinguished from case law. So what's the deal? You have legislatures and you have judges. So we have obviously balance of power, right? So what happens is the legislators write rules and then the judges' hands are tied based on those rules. So in last year this time, Violence Against Women Act was what's the word? Yes, it came down from the federal court, the Violence Against Women Act. How many of you do not want there to ever be any violence against women and children? Raise your hand. Sounds really good, right? Okay. Unfortunately, the people who wrote the bill don't understand the nuances, especially when it comes to parental alienation. And they dangled the power of the purse and said, here, states, because obviously the states cannot enact federal legislation because I think it's 10th Amendment, right, Demos? So they said, here's some money. Here's a lot of money for you states. If you mirror the Violence Against Women Act and pass it in your states. So California was the first state in August of 2022, to my knowledge, that tried to pass a law. It was at the time Senate Bill 661, Peakwes Law, that mirrored the Violence Against Women Act. And the bill was killed at the time. So in addition, besides legislation, the judges can use case law to make orders. So the bench officers are bound by either the family codes and the welfare and institution codes and the California rules of court to make rules for the people that are in front of them, the litigants. And they're also bound by case law, precedent. So it's a mistake to think that a bench officer can listen to all the everything they hear, all the facts, and make a decision. No, oftentimes their hands are tied. And so they are bound by whatever the legislature puts into place. That it's the rules. It's like playing a game of Monopoly. And you have the rules of Monopoly, right? But then there are exceptions to rules and exceptions to rules upon that. So if you play a game of Monopoly, but on Tuesdays you can only roll do they have dice in Monopoly? Yeah. You can only roll the dice with your eyes closed, standing on one leg, but on Wednesdays, you have to use your left arm. I mean, that's how it works with these bench officers. They're stuck with rules. They have to follow them. At the same time, they do have discretion. And so we have a judge coming in right now that talked in her presentation yesterday about how she handles her courtroom. I would like for other judges to be able to handle their courtrooms the way she does, because they have discretion to make orders, but they are also bound by legislation. I'm going too long. I'm going to finish soon. Okay, so I mentioned that in August of 2022, California tried to pass Peakwes Law. It failed. These laws are coming up in other states now. To my knowledge, Colorado's passed a state bill that's comparable to the Violence Against Women Act. I see some people nodding their heads. I haven't done my research with regard to the language of that bill, but I will say that we, a group of us, may I name names? Dr. Steinberg, Regina Marshall, and others, and I looked at Peakwes' bill that's coming back down, Senate Bill 331, just recently, and the language has gotten even more sophisticated. And do you remember we talked about 3190 and 3191 may order counseling? The ability of bench officers to order counseling is now being handcuffed as well in the new Senate bill coming out in California. So at the end of this presentation today, before we conclude the entire conference, I will be having a call to action for people to think about ways in which we can work together to raise educational awareness, so that as each state is being tempted with the federal funding, we can help protect families by educating the legislatures on the correct language to use in the bills, so that the judges are able to make orders that protect families. Does that make sense, what I'm saying? I'm talking so fast. Allison.
It does, but can you clarify the new Peakwes bill? In what way does it handcuff?
I'm going to have you do that.
Sure. Is it a handcuff?
Yes, I'm going to have my esteemed colleague share that with you momentarily. Here's a picture of me at the Peakwes bill in August of 2022. You guys, I had to speak after Peakwes' mother, and this was a woman who's advocating for the domestic violence agenda because her son was killed. And it was very difficult to go after a woman who's trying to pass a bill to say that we oppose the bill, and here's why. The real issue here is that the parental alienation community is another form of domestic violence, and the DV community does not necessarily understand the flip side of the coin, and they need to be educated. So I'm going to conclude my section. You can get a copy of this PowerPoint if you want it, and hand the microphone over to Brian Ludmer.
Okay, let me start, just pick up where Virginia left off about SB 331. So it's easily searchable on the internet. You'll see the specific language. The upshot is that it cannot be saved with any tweaking of the language. It will prohibit the remedy that Family Bridges uses, and the vast majority of these interventions are not done through formal programs because there just isn't the capacity in the programs that Virginia mentioned to handle the number of kids who unfortunately have to be ordered into some sort of temporary protective separation. So the vast majority of this work is happening just with local, experienced, family systemic practitioners. And if we don't have the ability to do this, and you take that remedy away, then this morning I spoke about the stark dilemma that courts face at the end of years of trying conventional therapy and compliance motions. If you don't have the ultimate remedy of a temporary protective separation, it will be chaos. So if we anticipate looking forward the next 3 or 4 years in Colorado, it's terrible that we would be doing this scientific experiment on our children, but we're going to have an explosion of broken families without solutions. And then this law will be repealed, and the only question is how many children will be lost in the interim, which is a very sad statement. So what I want to do is I want to just briefly put this denialism epidemic in context, because this is our issue, but denialism is part of a broader pattern of public discourse where instead of focusing on actual facts, louder voices are drowning out more insightful voices. And so what I did do is I put together a bibliography here. So those of you who sat in on the very early morning, 7:30 a.m. experts panel that Demos and and I were on with, I don't see Ali here. There's a list of books there that all experts should read. Here's a list of books on this topic and newspaper articles. See if I can get it to scroll down. Okay, I clicked in it. Okay, there we go. Just do it here? Okay. So you can see how, two-finger? I'm not a Mac person. There's actually an awful lot written on it, and a lot of newspaper articles as well. This epidemic of loud voices drowning out reason, discourse, probably reached the pinnacle when a judge of one of the U.S. Federal Court of Appeal circuits went to Stanford Law School to give a lecture and got hooted down and abused with the assistance of the law school's diversity officer, ultimately leading to an apology from the dean of Stanford Law School. So this is the world, unfortunately, that we're living in, and I've scrolled down to the article section of this, and one of these articles is about, it's from the Wall Street Journal or the New York Times, about that event. So what are we going to do about it? I've given, in the last 3 months, somewhere between 50 and 20 media interviews. And these are the people who are busy seizing on a most unfortunate situation playing out in Santa Clara, California, and a similar most unfortunate situation playing out in Utah, and children disappearing from court-ordered placements with the assistance of a whole social media infrastructure, just completely uncivilized, detrimental, antisocial behavior in a very organized fashion. This is what denialism leads to. Social chaos. Can't have that when the task that we're facing is as difficult as it is anyway. So we have to counter it. The media interviews so far are not working. Just about everything that I've explained, that I've spent hours with some of them, has just wound up on the cutting room floor because it doesn't sell eyeballs. It's introspective, it's analytical, you're trying to teach them why we need ultimately this unfortunate remedy of protective separation and how it's not so bad and the family can heal, and it offers the only opportunity for kids to leave childhood with two parents and two extended families. They would much prefer to focus on the chaos and the yelling, screaming voices and the rhetoric of camps and pseudo parental alienation and all the other adjectives that they've developed. So the way to counter it is we need to structure and have available all the science that we're hearing at this conference. It's all there. So we know what the answers are. We need to assemble it so that people are not having to prove this in each individual case. Then we need summaries that are bite-sized for the media on each individual topic so that, oh, this, look at page 22. There's a one-page summary of this issue. And if you want to dive deeper, here's the website with all the materials. That's the only thing that's going to work. But if you want to understand what's going on in its broader context, here's your list, and including some courses on this very topic. University-level courses through a company called The Great Courses. I have a whole bunch of their stuff. It's absolutely fantastic. and you can do it new school instead of old school, and just get an online access to it. And here's 4 courses right on the issue. Thank you.
So really quickly, thank you everyone for being here, and please keep going all the way to the end of the presentation. Dr. Burnett has asked me to say that the showing of the film is at 6:30. The program has a typo on it. One of the pages says the showing is at 7, but it's actually starting at 6:30, and it's here in this room. And also, I did not say this when I introduced myself. You'll find out later what my role is going to be starting in 2024 for PASG. But I am going to ask each of you to really deliberate on what you've heard during this conference, and there will be a call to action. Each of you has the perseverance to be here, the passion and the dedication to attend this conference, and each of you will be asked to step to the plate, and you will have your at-bat. And so think about that. If you have to leave early, please send an email to me, and my email address is Virginia, spelled like the state, Virginia, at griffindonnell.com, and the spelling is on the pens that is inside your little grab bags. Griffin Donnell, GriffinDonnell.com. If you're leaving early. Otherwise, at the end of the conference, I'll be asking each of you to call to action. So I just wanted to say that before we all leave for this afternoon.